Morena koutou. Welcome everyone to this next seminar in the Te Puna Haumaru seminar series. This morning it is my absolute pleasure to invite, or to present, I should say, Dr. Katerina Hadjimatheou, who will be talking about her research looking at domestic violence disclosure schemes internationally. Kat is a senior lecturer in criminology at the University of Essex in the United Kingdom. Her work focuses on technologies and data in criminal justice, security and policing, particularly in the field of domestic abuse. In 2023 to 24, she held a British Academy Mid-Career Fellowship, which took her around the world to look at how domestic violence disclosure schemes are being implemented and what we know about how they work. So today she's here to talk to us about that work. I'm really interested to hear about it, and I'm sure you all are too. Over to you, Kat.
Thank you so much, April. It's great to be here. I'm really excited, and especially because this is the first time I will be presenting my emerging findings from my New Zealand study. So yes, as I was saying, I'm quite excited because over the last year I travelled around to a number of different countries, including Canada, Australia and New Zealand. I was lucky enough to be in New Zealand in October, and I'll be presenting to you some of my findings from research in the UK and in South Australia, and some of the analysis that I have done from my research in New Zealand, which is I'm still working on the analysis, so it's a work in progress, and I'm really keen to hear your views and feedback. So I'll be talking to you about domestic and family violence disclosure schemes in an international perspective and addressing the question how criminal history information is being shared to address serial abuse. So I'll tell you first what these schemes are all about and how they started. Back in 2013, England and Wales, which is a jurisdiction in itself in the UK when it comes to policing, introduced the first domestic violence disclosure scheme in response to the murder of Claire Wood by her longtime partner. Now, Claire Wood had left her partner, who had a glittering history of serial and serious domestic violence against many partners. But Claire didn't know this, even though the police did, and she went back to him and he killed her. So her father campaigned at the right time, really, because police were already looking into ways to address serial perpetration, to introduce a right for members of the public to request and receive from police information about their partner or ex-partner's criminal history where they were at risk of what we call domestic abuse, and in New Zealand you call family violence. Now, the domestic violence disclosure scheme was rolled out in 2013. There are two pathways to receiving a disclosure. One is that a member of the public will apply to the police online, describing their situation and asking for the information. And the information is shared by police with that person if there is a relevant history. It was initially only in person, but as time has gone on and with COVID, it's increasingly done by video call from the police, sometimes with the presence of a specialist support worker, but in the vast majority of cases, no. And in England and Wales, police have the power to share any information they hold on their systems that is relevant to the risk of domestic abuse. So this goes beyond convictions to reported crimes, allegations, and so on. And it's important to note that there has not been, in all of the years since it was introduced, a single case of litigation by a suspect under privacy law for the disclosure of information about them. And that's notable given that last year alone, well, in the last recorded year, which ended 2023, there were over 45,000 applications for disclosure in England and Wales alone. So the one pathway is what's called the right to ask. A member of the public asks for the information and police can share it. The other pathway is called the right to know, and that is where police identify a risk, for example, a known suspect of domestic abuse leaves prison, for example, and starts a new relationship. Probation officer may become aware of the new relationship, and police may decide to try and contact and warn that new partner about the risk they face. And that's called the right to know. That has been used less historically than the right to ask, but increasingly now it is becoming a routine part of what domestic abuse police do in the UK when they do safeguarding work. I'm sure those of you who are unfamiliar with the schemes will have lots of questions about who gets to have the information, third-party applications, and so on. I'm happy to answer those later. A third party can make an application, but the information will only be disclosed to the person at risk. The person at risk cannot share the information with anybody else. They have to keep it confidential, and they have to sign a legally binding declaration that they will not share the information with anybody else. And they are not allowed to keep a copy of the information or take notes. It is relayed orally. They can ask to hear it again, but that is as far as it goes. And that is, of course, because this information, for the most part, is not in the public domain. So that's what the disclosure scheme in England and Wales does. And it has been adapted and replicated in various forms since then in countries around the world. And every year there is at least one more country that introduces domestic violence disclosure schemes. So, for example, just in the last 18 months, Malta and Spain declared that they were introducing schemes as well. So my research on these schemes starts back in 2019 when I stumbled upon them doing a study on how police use data. Very broad study. That's my background, police use of data, the ethics of tech and data in a policing context. And a police officer said to me, actually, we've got something relatively new. We've had it for a while, but we're using it more now. We share criminal history information to protect people at risk of domestic abuse. And I found it fascinating, ethically, potentially controversial. So I started interviewing police around the country to ask them how they made decisions about where the threshold lay, how much information they disclosed, how they managed eligibility, what impact it was making on people in a relationship, what kind of responses and reactions people had. It was an exploratory study. There had been no research, empirical research that is, done on it before. And I interviewed 32 police officers who were directly involved in either making disclosures or authorising them in 14 different forces. We have 43 forces in England and Wales. It's a regional, fragmented policing system. And then I've gradually built that up. Last year I travelled around, as I mentioned. I also launched a survey for people who have applied for or received or been offered disclosures in England and Wales, which has 350 responses. Not very much if you think about 45,000 applications, but it's the only research that's been done. And in autumn of last year, I spent some time in South Australia where they have a disclosure scheme, and crunched through a lot of data they have been gathering about how that's working. And a link will be shared to the report. It hasn't been formally launched yet because the NGO that runs it wants to do their own press around it, but I am able to share it with you. I've asked that. And of course, I did some research in New Zealand, which I'll be telling you about later. So the questions I want to address in this talk with you today: how are different models of disclosure scheme working for victims and survivors and for people at risk? What lessons can we learn from practice around the world? What principles should inform the design of disclosure schemes? This is important because different jurisdictions do take opportunities to review their practice. And that's an opportunity for research to come in and say what the evidence shows works and is best practice. But also, as I mentioned, new jurisdictions are introducing disclosure schemes every year. So it's important to have some evidence that they can draw on when they're making decisions about, for example, eligibility. So I'm going to make some key claims, just a few key claims in this talk today. The first is that the disclosure of criminal history information can empower victims and survivors. That's the main contribution it can make. It can empower them in their relationships to improve safety, and it can counter coercive control. And it does that when it reveals a pattern of behavior. And I'll go into some depth about the importance of that pattern. I'm also going to argue that the process of applying for or receiving a disclosure can itself be beneficial. It can improve safety empowerment itself, even when there is no information to disclose, but only when it is delivered in a trauma-informed, victim-centered way, and when it respects the autonomy of the recipient of that information, their right to choose what to do about their relationship and about their safety and about their family. I'm going to say that the New Zealand Family Violence Information Disclosure Scheme is falling short of achieving this potential. So disclosure schemes can make a real contribution to the protection of victims and survivors, but the New Zealand scheme is not currently doing that. And there's one underpinning reason for that. And that is because it is designed in such a way that it prioritizes the protection of police from legal action, litigation under privacy law, above the protection of people who are at risk from family violence. So I'll be giving you some reasons why I think that as we go along. So to start with, the contribution that such schemes can make to efforts to counter domestic abuse and family violence. We can understand this if we start thinking about the role of truth narrative in the perpetration of domestic abuse. So just to get us in the right headspace, this was the only theory I'll be inflicting on you in this presentation, and it's only one slide, so bear with me. But domestic abuse increasingly is being conceptualized in terms of what's known as coercive control. And this was a concept developed in depth by Evan Stark in 2007. And it interprets or accounts for domestic abuse as not just incidents of physical violence, but the systematic oppression, most typically of women by men, but not exclusively, through the denial of freedom and autonomy. So it's that denial of freedom and autonomy that knits together into a kind of pattern of abuse, a course of conduct, the different incidents or moments of abusive behavior. So it's not just physical violence, although it can be, but it typically incorporates also emotional abuse, the isolation of a person from their family, their friends, their work, their sources of self-efficacy and self-confidence, financial abuse, sexual harm and sexual violence, deprivation of liberty by not letting somebody go out or manipulating them so that they think they shouldn't, locking people up, threats of various kinds, including to children, to family and pets. These are just some tactics. And one of the underpinning tactics as well, which has been mentioned in some of the literature, but it isn't a kind of headline finding, but is important to what I'm going to argue today, is what's known as the monopolization of perception. And what does that mean? It is essentially when a perpetrator of domestic abuse enforces the acceptance of their version of reality, their perspective, their interpretation of reality on their victim. And they do that to expand their scope for control and to undermine their victim's capacity to exercise independent judgments. It's that denial of freedom and of autonomy, of the agency of the person to make decisions for themselves and decide what's right and good for themselves. And this monopolization of perception, there are various ways in which it is inflicted through minimization of abuse and harm, outright denial, and I'll give you some examples of that, gaslighting of people, and blaming the victim and previous victims for abuse. And so we have the phrase, look what you made me do, as emblematic of this kind of abuse and twisting of the narrative. So I think if we start thinking about that, the role of narrative, the role of the monopolization of perception in domestic abuse, we can start to see where a domestic violence disclosure scheme might come into preventive measures. Now, the findings from my initial research with police in England and Wales and my research with the South Australian data suggests that sharing criminal history information can empower people at risk, it can improve safety, and it can counter control when it reveals what my police participants described as a pattern of behaviour in a subject's offending. And when that pattern exposes the perpetrator as a dangerous person. And I'm going to give you some examples now of how that works in practice. And I'm going to argue that that empowerment occurs differently at different stages of a relationship. So I'm now going to give you some quotes from my qualitative research with police in England and Wales, and also from the free text feedback that was given by 250 recipients of a disclosure to the South Australian disclosure scheme. So at the very start of a relationship, maybe unintuitively, because disclosure schemes are often described as being an early intervention. There's something that will make a difference at the very beginning of a relationship where somebody thinks, maybe there's something not right. I've got a gut feeling, or somebody's told me something about my new partner. I'm going to go and check it out. They'll receive the information and then they'll leave before the harm happens. Now that can occur, but what the research is showing is that it occurs rarely. Because at the beginning of a relationship, people are happy, people are being treated well, people do not have reasons, to seek that kind of information. And if they're offered that kind of information, it just does not reflect the person they have come to know at that beginning stage of their relationship. And if people aren't ready to hear information, then it will not land. However, some of my participants described to me that sometimes they did see a value, a chink at the start of a relationship. And they described that in terms of planting a seed. So one police officer said to me, she offered somebody a disclosure, but that person didn't want it. She rejected it and said, no, he's different with me. He's a great bloke, no violence. But then she called me 6 months later to tell me how very controlling he was. And now she could put the pieces together. So now we move on once a relationship becomes entrenched. And there it was described to me that the value of a disclosure can be quite different. What it can do there is start to counter that false narrative that is being imposed and spun by a perpetrator. So one officer said to me, we can be open and honest. And knowledge can be power because, well, experienced offenders can spin a nice line in terms of those previous victims and previous incidents she might be aware of. This is police telling her the facts of the case rather than his version of events. And one survivor in South Australia wrote, he told me she accused him of abuse to get custody of the children, and I was stupid enough to believe it. Can you read it back to me, please? I need to hear it again. In fact, this quote, I should correct, this wasn't written. I sat through a disclosure in South Australia, and this is what the person said in that meeting. So again, once the relationship is in that entrenched phase, disclosure can also be useful in challenging a narrative around rescue. So if I just stick with this person and help them through their PTSD or their alcohol problems or their substance abuse problems, they're going to change, they're trying to change, and I need to be patient and help them with that change. It can challenge that narrative. So one police officer said to me, for people who are borderline, where they're thinking, I want to believe my partner is good, I think the disclosure scheme is useful because it highlights that it's a pattern. You can't fix them. It's not you. And this was echoed in the feedback of one survivor in South Australia who said, it helped me realize I'm not the cause of his abuse, as he's done this before, and I can't change him. It gave me the strength to say, I've had enough of being abused. And it's important here for me to emphasize that when I asked police in various jurisdictions, not just England and Wales or South Australia, but in New Zealand, in Canada, I'm hearing the same responses, despite the context. It's irrespective of the legal context or the social context, that typically they are not seeing information where there is one incident in somebody's past. These do tend to be serial perpetrators with a significant history of abuse over a number of partners. And so when that is the typical kind of disclosure, we can start to see that a pattern will be visible when those incidents are disclosed. So a third way in which those disclosures can help to empower and counter the abuse is by shifting that blame. So one police officer in England and Wales said to me, she described the case of a girl who was in hospital and the police had been called because of the nature of her accident or her injuries. And she said she was pregnant and she had a saucepan mark on her stomach where he had burnt her. And she was saying, this is a freak accident, I made him do it. But he had burnt the stomach of a previous partner who was pregnant with an iron. It demonstrates a propensity to a certain crime. So I could say, this is a dangerous man. This was not something which happened by accident. This is what he does. And again, this was echoed in the words of one survivor who said, I walked out of the disclosure with a sense of relief. It took a huge weight off my shoulders that it wasn't me. It was the same pattern of abuse to his prior girlfriends. It gave me a feeling of being shame and guilt-free. I cannot articulate the freedom I feel now. This was the start of my recovery. And I think it's important to emphasize the role of shame, of feeling that you're the only one, that you're the reason this happened. And also being able to recognize in that pattern what one is experiencing themselves. So when a particular kind of behavior is described to somebody who is experiencing exactly that behavior that themselves, that can be incredibly powerful. So even at the end of a relationship, in fact, especially at the end of the relationship, it was emphasized to me that a disclosure can be really, really important. And it can be important in confirming those decisions to leave and helping people to stay away. Various officers in England and Wales underscored this point, saying it can help those walking away from a relationship by verifying concerns, checking on their decisions and making sure, and helping them make their mind up if they're ready. And again, two survivors, one from England and Wales, said to me, it made me confident I'd made the right decision to leave. And in South Australia, it validated my experience. Hearing it read back was difficult, but affirming that I could never go back into that relationship. And again, the importance of this should not be understated, because people who work in the field of domestic and family violence know that the point of highest risk is when somebody tries to leave or has left, and that often people do go back, and there are multiple times of going back and leaving, and the risk at those endings is very, very high. So anything that can help them it should be valued. But even after the relationship is over, a disclosure can be valuable in helping somebody to understand the risk they face and staying safe. So one police officer in England and Wales described to me a case where the perpetrator didn't even live in this country. He lived in New Zealand, as a matter of fact. But the applicant was subjected to stalking behavior and was assaulted. Despite her restraining order, he was still emailing her. I asked her, why do you feel you need this? And she said, I'm worried he's going to return sometime in the future. I want to know, should I move elsewhere? And he did have more history beyond her, where he did harassing and stalking long term. And she said, I know now to sell the house, and I know that he won't let go. So in the perspective of my participant here, she said to me, this was a safeguarding decision that this person had to make. She had to make a decision about where it would be safe for her to live. And this information helped her make that decision, even though the relationship was over. Now, these positive findings are strongly supported by the research that I did in South Australia at the end of last year. So the South Australian disclosure scheme is kind of co-produced with Women's Safety Services South Australia, who coordinate it, and the South Australian Police, working in partnership to deliver this scheme. They received detailed feedback from around 250 participants, which is about 20% of all of those people who received a disclosure. So it's a very significant, in academic terms, this is a significant sample size. It's a robust piece of it's a robust feedback. And you can see here from the statistics just how positive the feedback was and how valuable clients of their disclosure scheme found it. But I also want to emphasize the first bullet here is the opportunity that such disclosure schemes present to reach people who are not receiving support for the abuse that they're facing from anywhere else. So 67% of those who responded to this survey in South Australia had never received support for domestic abuse from domestic abuse services. My own research, my survey in England and Wales, which has 350 responses, 40% had never had any contact with police before their contact with the disclosure scheme, and around 20% had never received support from anyone, including peers, for the abuse. So this is a real opportunity for services and for police to reach people and to support them and to help them through these times. And I mean, you can see quite clearly here, there's a 99% said they were very satisfied, more than satisfied, or satisfied with the service that they received and with the information that was provided. 98% said the information and the process helped them make decisions about their personal safety. And 95 were helped in making decisions about other aspects of safety, including the safety of their children and their pets. And in the free text from the South Australian client feedback, I analysed that in a qualitative way. And here you can see the kind of different elements of empowerment and safety that were articulated in that free text. So people feeling supported and helped to make informed decisions, people who, as a result, decided to leave their partner or to stay away from their partner. People felt safer and felt their safety had been improved. They felt an increased sense of freedom, a lack of being controlled. They used terms such as empowerment, reductions in shame and self-blame, increases in self-confidence, self-validation, feeling better, feeling relief, feeling that they understand now for the first time the risk they face, feeling heard, listened to and given voice, and improved awareness of domestic violence and red flags. And it's important to note here that this partnership delivery in South Australia involves direct contact only with women's safety services. So the contact between an applicant for a disclosure and the police is limited to the online form, which goes to police, which assesses eligibility in the first case. And the police show up to the disclosure meeting and they deliver the information and then they leave the meeting. So a call is received, everybody, irrespective of whether there's information to be disclosed, a call is received by a specialist domestic abuse worker. That person also coordinates the meeting in a safe place at a safe time. That person then stays with the recipient of the disclosure after the police have left to talk through safety plans, to raise awareness, to do some domestic abuse education with that person and connect them with other kinds of support. So it's working very well. However, all of this positive stuff will only be effective, or at least that's what my findings from the last year of research suggest, will only be effective if certain things are in place. And one of the reasons why it's important to emphasize this is that these things are not in place in all jurisdictions. There's quite a lot of variation. So the first thing that needs to be in a disclosure scheme is that police need to be able to disclose patterns, and that means modus operandi and reported incidents. And this is important because only a tiny minority of reported domestic abuse crimes ever result in a conviction. And that's the same whichever country you live in. In England and Wales, it's about 4.4% conversion of incidents reported to a conviction. So just think about the amount of information that is available, visible to police at the touch of a button, and how little of that they would be disclosing to somebody at risk if they limited it to convictions only. And what a tiny and distorted picture that would give that person. And we know that convictions alone do not convey actual risk. Risk assessment tools, none of them in any country in the world limit the input to a conviction. They take that behavior into account, and behavior goes beyond convictions. Also, if we were to limit disclosures only to convictions, the language often is uninformative. So convictions are typically relayed in legalistic language or police language: assault, a public order offence, harassment. These are empty phrases that could be filled with any interpretation a suspect or perpetrator likes. They don't mean anything to most people. Assault could be anything from a push to something much more serious. So we need detail, and in terms of behaviours that people, members of the public, understand. And that full picture is really important if that false narrative is going to be effectively countered. So my survey with 350 lived experience users of disclosure schemes in the UK found that I asked people, did you know something about your partner's criminal history, whether that was a kind of rumour or something in the community, or whether it was a history of contact with the police. 69% of survey respondents said, yes, I knew something. And then I asked those, did the disclosure tell you something new? And 70% of those who knew something were told something they didn't already know by the disclosure. And we'll see in a moment why that's important in a New Zealand context. It's also vital that long-term partners, so people who have been in a relationship for a long time, and ex-partners qualify for disclosure. I've already said that a disclosure is at its most powerful when a recipient is ready to hear it. I've also said that the point of highest risk is when somebody is trying to leave or has recently left. Also, it's important that a victim or a survivor may understand the risk they face in a relationship, but they may not understand how that risk might escalate when they try to leave. And so a disclosure can inform them of that real risk. And also, we know, anybody who works in or researches domestic abuse knows that post-separation risk can persist in the long term, because in many cases people have children together, or they have family friends in common, or they have friends in common, and so they are still in each other's lives. It's also essential that the disclosure process is victim-centred and trauma-informed. What does this mean? It just means that the victim's safety and their well-being should be at the centre. There should be the central defining principle of a disclosure scheme. And also to understand how trauma might affect the way that victim or survivor might interact with professionals and might receive that information. In practice, what does this mean? I think a number of things, amongst which minimising in-person or direct contact with police. And police should not be wearing uniform when this is not an operational element of policing. There's no reason why uniform should be worn. Many people are frightened of police. Many people don't trust police. Many people are worried about either grassing up their partner or themselves becoming implicated in something. Many people have a history themselves of contact with the police. And all of these things can inhibit somebody from seeking a disclosure or going through with it. So there is in all countries, surprisingly, you might think there's quite a high attrition rate. So people who apply and then don't show up to get the disclosure. So the role of police should be minimized and should be defanged, as we might say. Disclosure should take place at a safe time and place for that person. Often people are surveyed by their partners and monitored, and it's essential that their safety is paramount. And there should be a specialist trauma-informed support there. Whether that is a police officer or not, I don't take a position. It may be that police can receive excellent training in this field, but in most cases, this will mean a specialist worker who can talk to that person on an equal plane rather than the position of authority and power that police tend to have, can help that person deal with the fallout of a disclosure. A disclosure can be terrifying, especially if somebody hears really, really serious violence or sexual violence and then has to go home to make dinner for that person. And a specialist can help them plan for safety. Recipients should be allowed to share the disclosure information with a support person. In South Australia, this occurs. In fact, people can bring someone with them to that disclosure. The legal requirement not to share the information further still applies, but it recognises the fact that it can be incredibly isolating to give somebody this terrifying information and then tell them they're not allowed to talk to anyone about it or they'll be arrested. The disclosure should be given in a non-judgmental manner. So that means no demands on the recipient to report their partner or make a statement. It's not a reciprocal exchange between police and a victim. You help us, we help you. This is about protecting the victim. And people should not be pressured to leave the relationship because that can poison then their willingness to come and disclose or discuss what's happening to them again. I also think that disclosure scripts should be accessible, that is, delivered in a way that is appropriate for people with neurodivergent backgrounds, people from different ethnic backgrounds and so on. And recipients should be allowed to take it and read it and hand it back. And they should be allowed to ask for a repeat of the disclosure. When you are hearing very frightening information, it can be very, very hard to take it in and remember what you've just heard, especially when the list is long. So it's important that that information is, people are enabled to absorb it, especially because they cannot take it away with them in any way. So I've told you how I think disclosure schemes can be useful. I've told you what I think needs to be in place for that potential to be realised and cashed in on in practice. And now I'm going to tell you what I think is happening in New Zealand. So the New Zealand Family Violence and Information Disclosure Scheme was launched in 2015. It was only the second globally after the English and Welsh one. It is only eligible cases are those that have been risk assessed as high risk. So if it is a medium risk relationship, it will not meet the eligibility threshold for a disclosure. Similarly to the UK, to England and Wales, there are two pathways to disclosure. There's a reactive application, and that is an application that's made by a member of the public. That is hardly ever used. According to my participants, there were very, very few cases they had ever seen of that being used. The proactive application, which is made by police where they identify risk, that is actually the vast majority of practice we're seeing in New Zealand at the moment. Now, what information is available about how the FVIDS is working in New Zealand? Very little. My request for information under the Open Information legislation revealed that there is data on rates of application and rates of approval. So how many applications have there been annually and how many have been approved for disclosure? That is the only information that police hold and can disclose. There is no information on how many of those applications are reactive and how many are proactive. There is no information of the demographics, who is seeking this information or who is being offered it. There has been no attempt to gain feedback from people on how it works for them in their relationships. And there has been no attempt to analyse the impact of these schemes on family violence. There has been no review of the scheme since it launched in 2015. And as far as I know, there has been no research on it to date. So there's not much to go on. My own study involved two kinds of data. One was, as I mentioned, an Official Information Act request, which revealed to me application and approval rates, and since 2015, not 14. And I also undertook some in-depth interviews, which were really amazingly supported by New Zealand Police. I made an application to the police and they authorised the research, and they also helped me connect with people in the police who were making disclosures and applying for them as well. And they were very keen to see practice improving. So I undertook 5 interviews with New Zealand Police who were involved in FVIDS, and 4 with specialist family violence support workers, and 1 with a survivor who had applied. So just to give you a quick overview on the rates of application. So we can see in the line graph, I've compared New Zealand to England and Wales and South Australia. There's generally a tendency for disclosure schemes to gather momentum over the years as more and more people become aware of them and police become more confident in disclosing that information and in making proactive disclosures. And we can see that in England and Wales, and we can see it in South Australia. But if you look at New Zealand, that's not happening. In fact, there has now been a 2-year sustained drop in the rates of application. And you can see in international comparison that New Zealand falls right at the bottom. So if we're looking at rates of application in the context of the local population, New Zealand is very low. Now, what about how those applications convert to approval rates? You can see there on the line graph that, again, approval rates have been quite low in New Zealand, and relatively speaking, they are quite low as well when you compare to other countries around the world. So why? And that's where the interview data I had come in. Why are there low rates of applications? So public awareness is poor. There's been no real public awareness campaign since the launch. Police don't know about it. The process isn't victim-centred. So it's the only jurisdiction where somebody has to walk into a police station or phone up the police to make an application. In all other jurisdictions, apart from one in Canada, it's an online form that people can fill in. Eligibility in New Zealand is limited only to persons who are in a new relationship. And of course, how do you judge new? Well, each district decides it differently. But it certainly wouldn't be someone in a relationship for a number of years. And police are only disclosing convictions, or they might disclose reported incidents when those incidents are causally linked to a conviction. So there's a whole process of retrospectively trying to connect a conviction to behaviour and then maybe disclose that behaviour. And the process is bureaucratic and legalistic, and it's discouraging police from trying in the first place. How about the relatively low application to approval rates? So number of applications that are actually being approved for disclosure. Well, one of the barriers is that police officers must complete an 11-page form. That is a long form. Police are doers. They don't like paperwork. It's enough to turn anyone off. And they also have to defend their recommendation for a disclosure to a panel of more senior officers and legal officials. And policing is very hierarchical. That's an uncomfortable place to be in. Also, decisions about disclosures are made typically by a panel in New Zealand, and that involves a police lawyer and a commissioning, so a senior officer. Now, neither of those people making the decision need to have, and in my research, I was told they typically don't have any training, experience, or even understanding of the dynamics of family violence, or how risk assessments are done in family violence. So you have people making the decision that don't understand family violence, but they do understand the law. And this is what I'm going to argue now, that the whole system is really prioritizing covering police backs and protecting them from litigation. And the reason for that is a problematic legal framework. Very briefly, I'm not going to go into detail, but what I will say is that New Zealand has a brilliant piece of legislation called the Family Violence Information Sharing Act, and it allows professionals to share information with each other where they reasonably think that it might help somebody protect someone from abuse. But they're not allowed to share the information with the person who might be the best place to protect themselves from abuse. So the Family Violence Information Sharing Act is about professionals sharing data with professionals. People are not allowed to share the information with the person at risk themselves. Instead, the disclosure scheme is governed under two pieces of legislation. The Privacy Act, that has a very, very high threshold for disclosure. There must be a serious threat. Police must first look to disclose to other people to check if somebody knows some information already, and then not to disclose to them if they do know something, and to disclose only the minimum information possible to help them make that decision. And very similarly, reactive disclosure, so when a member of the public applies, again, it's the Official Information Act, a very, very high threshold for police to meet, certainly much higher than the Family Violence Information Sharing Act. I have some nice quotes at the end. I won't go over them, but essentially what they say is, I felt this was a very good scheme from police, and then I tried to do it, and I thought it's useless because every time I apply, it gets rejected. And a survivor who I interviewed in New Zealand told me that eventually she was encouraged to do an open information access request for herself to the police, and only through her own information could she see that the person who had attacked her had 29 flags for domestic violence, but the police would not give her any information on what those flags meant. So my recommendation is that the New Zealand government should conduct a review of the FVIDS. It's been 10 years. It's a great opportunity. They should review eligibility, the legal basis, the process, and the monitoring. And that review should ideally inform a relaunch of the FVIDS driven by principles of harm reduction, being trauma-informed and victim-centred. And that process has to be done in close consultation with the family violence sector, with people with lived experience, with vulnerable groups, in order to make sure this is working for people at risk.